Okay, joining me now is Katherine Loftus, WBZ's new legal analyst, specifically for the Karen Reed case. Hi, Katherine. Can you just introduce yourself? Because this is going to be our viewers' first time meeting you.
Sure, that's thanks for having me, Kristina. My name's Katherine Loftus. I'm a local lawyer here in Boston. I've been practicing, going on my 11th year, working in the court system for about 15 years. I've been talking about this Karen Reed case on my social media, TikTok, places like that. So I'm excited to join you today.
Awesome. So we just got this decision, a pretty lengthy
We
decision
did.
from the Supreme Judicial Court denying Karen Reed's motion to dismiss two of her charges. Can you just give me first your first take from it? I know you just read it.
I'm not overly surprised. I think, given both the legal underpinnings of what actually happened during the trial, as well as the questions that we heard from the justices during the oral arguments last fall, I think it seemed clear to most that this is the way the court would be leaning. I'm not surprised that it was written by Judge Georges, who practiced criminally for quite some time and had some pointed questions for the defense counsel during the oral arguments. But I think it really comports with the law. It's a good analysis of how the law actually works, that it's very procedural, it's very technical, and the court went through, case by case, sort of line item by line item, all of the issues that the defense raised. But overwhelmingly, I'm not really surprised given what happened at the trial court, the decision that was made by Judge Cannoni, and really where the law stands.
I would love to go through it, not page by page, because that would take, but just kind
Sure,
of generally start to finish with you, if that's okay. I
sure.
want to start with the justices kind of laid out perfectly what the question they were analyzing is. They said, can post-trial accounts of jurors' private deliberations that are inconsistent with their public communications in court render the declaration of a mistrial improper or constitute an acquittal where the jury did not announce or record a verdict in open court? So correct me if I'm wrong, but I interpret that as, can jurors saying privately that they acquitted someone count if they didn't say publicly that they
Right.
acquitted
That
them?
that's exactly right. And I think they did that on purpose to expressly lay out what they thought the question was. And your recitation of it is exactly right. That it just comes down to, can any conversations, any potential decisions, tentative agreements, can those alter a jury verdict, whether it was not guilty, whether it was guilty, whether a mistrial was just declared? And I think that goes to really the crux of the case, that we have, our jury system, while it's not perfect in the United States of America, it's important to recognize the sanctity of the jury system, and that we respect the jurors, that these are the people who have taken the time to sit through trial, listen to all the evidence. And it's really counterintuitive to say that after they have essentially rendered their decision to the court, that we could then come back and, inquire of certain jurors. It really would make the process pretty messy and frustrating. And I think it's an interesting way to look at it, because I think, given the fact that it was for the defense was filing this motion, if we think about it, if we sort of change the parties, that if the Commonwealth in this case said, for example, maybe afterwards they found out that the jury said, oh, we were going to convict her on count one, would we want them to then call them back and make a decision and take that verdict? Probably not. So I think that the court really wanted to clarify that the sanctity of the jury is of the utmost importance in our system, and we need to keep that separate from post-trial inquiry.
And it does seem like the court even suggested that it would almost be like opening a can of worms to allow this type of inquiry. Did you get that impression?
Yes, because and if you think about it, it's complicated, and particularly in this case where the court outlines that the jurors weren't sending sort of basic unclear notes to the court. They were very concise, they were very clear, they became more and more insistent as they went on. And if we were to then, whether it's weeks later or months later, say, okay, we'll bring these jurors back, then you have probably different jurors saying different things, having different interpretations, and it really would just muddy the water. And that's not how the law is generally interpreted. So I think that's really where the court was going with it.
And I think, could you just reflect a little bit on how in this decision, the SJC seemed to reflect a lot on defense attorney's statements in court when this was all happening, when the mistrial was declared, and even before then, when the jury came back with notes saying they were deadlocked, the way that defense attorneys reacted in that moment. Can you talk about that?
Sure. So I think it was interesting, and that's why I was not surprised that Judge Georges was the one who issued the decision. When we were before the court on oral arguments, he specifically cited that this was a team of very talented defense attorneys and who are very sophisticated, understand the law. And I think it comes, the idea of tactic and strategy comes into play a little bit. You know, they didn't address that specifically, but what they said was, these are attorneys who know when to object. They have not been quiet before. They have made their positions known. They are well within their bounds that if, you know, at the moment that the judge was declaring a mistrial, they certainly had the ability to get up, and they didn't. And in addition to that, even prior to the declaration of the mistrial, we had the first note where right away the defense asked for the Tui Rodriguez instruction. It wasn't given. They again requested it. And really, when you're looking at in the moment, and that's what the judges in the Supreme Judicial Court are doing. They're looking at what did the judge, the trial court judge, have at the time? What was the position she was in? What was the information she had? She had the 3 notes from the jurors. She had no objection from the defense at the time. And so that's why when they look at it, they say she was in the position to make the decision. She was in the best position. She had all the information available. Defense counsel didn't object. They didn't ask for the jury to be polled, even after staying in the courtroom, picking new dates for scheduling, things like that. So it really does. The court wants to look at not only the underpinnings of the legal question, but what was actually happening in the courtroom and who had the best ability to make a decision. And that was the trial court judge.
Right. And can you just refresh for our viewers the Tui Rodriguez instruction? It's, if I remember correctly, defense was essentially in that moment asking the judge to move in the direction of a mistrial.
That's correct. So what a Tui Rodriguez instruction, it comes from a case, a Massachusetts case. And essentially what it says is that when a jury comes back as deadlocked, when they provide a note or other information to the court that says we can't come to a decision, if the judge decides that they're essentially really stuck at an impasse, they read this decision, this court instruction from the Tui Rodriguez decision that essentially says, take one more shot at it. Take a step back, look at what the alternate options are. What is the other side saying? Are you really truly, listening to the other side? Are you taking these different perspectives? So generally, it depends on sort of how long the jury has been out. I think the first note was 19 hours, if I'm correct, before they came of deliberation, before they came back with the first note. And once the Tui Rodriguez instruction is read, it's essentially all the parties know. The defense, the prosecution, everybody knows it's going towards a mistrial. And once the instruction is read, you can't go back. You can't send the jury back unless they consent to it. So when the defense was asking in the very first note, and the Commonwealth objected to the TUI instruction, that gives the court, both the trial court judge as well as the SJC justices who are looking at it from the outside lens, that in the moment, the defense knew that they were leaning towards a mistrial, asked for the TUI Rodriguez instruction right away. And so that sort of goes into the insight of the strategy and the tactics of where the defense was at the moment.
Mm-hmm. And as you and I had discussed, this is really a technical legal decision, right? But for the general public who follows this case, especially those who support Karen Read and believe that she's innocent, there's been this conception publicly that maybe what's legal isn't the same as what's fair. Can you just reflect on that?
And I don't think it's an unfair assessment, because I think most of us understand, hey, if they had come to a verdict on counts 1 and 3 and they were all in agreement that she was not guilty, of course you want a defendant to be entitled to that verdict. Unfortunately, because the law is so procedural, if we really sway outside of that, like we talked about earlier, it just becomes messy, right? Because we take all these extraneous pieces of information, and it really complicates sort of the whole underlying process. But I don't think I completely understand why, from a lay person's perspective, that it would seem like that doesn't seem right. That if they did in fact come to a not guilty, verdict or decision, in the jury room, why shouldn't it be taken? And fortunately or unfortunately, whatever way you look at it, the law is very procedural, and that unfortunately it has to be followed. And it is not always, the criminal justice system. I think it's in the United States of America, it's probably the best we have in the whole world, but it's not perfect. It's not perfect. And, I think that some people could look at it as a bit of an injustice. But unfortunately, that's the way the law works.
Mm-hmm. And on the note of the verdict or lack thereof being either publicly read or maybe discussed behind closed doors, part of the defense's argument in this appeal was double jeopardy, a constitutional right to basically not be tried for the same crime twice if
Right.
you've been convicted or acquitted. The court rejected that contention. Can you just talk about that?
Sure. So the double jeopardy, what the ruling was double jeopardy doesn't attach. That our case law, long-standing case law, states that if a mistrial is declared, and that's based on manifest necessity, which essentially means that it's impossible for a fair result to be reached, and the court evaluates all of the options and alternatives and then declares a mistrial. If a mistrial is declared based on an evaluation and a conclusion that manifest necessity is there, then double jeopardy does not attach. So jeopardy doesn't attach when the jury is in the jury room thinking about it, analyzing, deliberating. It only attaches when a verdict is returned. If they had returned a verdict on, counts 1 and were hung on counts 2 and 3, she couldn't be retried on count 1. But unless the verdict is read in open court in front of the judge, in front of the parties, and affirmed, then jeopardy does not attach.
Okay, so I have two more things I want to discuss
Sure.
before I let you go. One is that I just got a statement from defense attorneys in this case, specifically from Martin Weinberg, who worked for Karen just on this appeal.
Right.
And he said, and I quote, "While we have great respect for the Commonwealth's highest court, double jeopardy is a federal constitutional right. We're strongly considering whether to seek federal habeas relief from what we continue to contend are violations of Ms. Reed's federally guaranteed constitutional rights." What do you think?
I think that I'm not surprised that that's the tact that they would take. I think they would get the same decision if they go to the federal court. I think the law is clear in Massachusetts. I think the federal case law is similar, and I think really the same result would end up.
Just procedurally, if they do appeal, what court do they go to next?
So they would have to go to federal court. So in Massachusetts and state court, obviously the Supreme Judicial Court is at the very top. There's the district court, the appellate court, and the SJC. Normally, a motion to dismiss is not. You don't have this is called interlocutory appeal. I know you know that. So you don't have the ability generally to go right up to the Supreme Judicial Court on a motion to dismiss, but they did because it's an issue of double jeopardy. So they would have to go to the federal court if they want to. I wonder if they will actually do that. I'm sure they will consider it, and I know that was in their statement. I think the likelihood of success there is pretty slim, so I'm not sure that it's worth the effort of going that route.
Okay. And then last thing I want to talk to you about is moving forward, obviously. I think there's been speculation even up until now that this April 1st trial might not even happen, even though we've been moving through court as though it's definitely happening. What does this mean now for the second trial?
I think as of right now, this doesn't mean anything for the trial's still on as of April 1st. I think from her perspective, it's already been continued once. It was on for January 25th or 26th, I think. And she's been very on top of the scheduling order. She wants to make sure that trial starts on April 1st. We have the motion. The judge, yes, Judge Canoni. And because that's what the job of the court is to really, make sure everything stays on track. We do have the motion to dismiss that's coming up to be filed next week. And then we have the opposition that's going to be heard at oral arguments in early March. But barring some other intervening circumstance, I think that we'll probably start on April 1st.
With 3 charges against Karen Reed still.
Yes, I think unless the Commonwealth decides to drop, it's always been my position that their strongest charge is count number 2. I think count 1 is a stretch and always has been, but that's ultimately up to the Commonwealth. The judge does not have any discretion to dismiss that. The only person who does is the Commonwealth, and I think it seems like they're going forward on all 3.
Okay. Anything I didn't ask you that I should have? I
don't think so. I mean, I think it's just it's It's one more thing to add in this really interesting case, and it really has been interesting to cover. And I think it's good for it's a good case for people to see how the legal system works and what is ideal and what's what we want to happen, sometimes what actually happens. So I think it's getting a lot of people interested in talking about it. So not a bad thing.
Awesome. Thank you. And thanks
Thank
for
you. Thanks for having me.
appreciate it.